Well, good evening, everybody. Thank you for coming. My name is Kate O'Regan, for those of you who haven't met, and I'm the new director of the new Bonavero Institute of Human Rights, which is so new that it hasn't actually opened yet and will only open in October. So this series of conversations with eminent judges from around the world that we're having this term will continue in the Michaelmas term. And I have to say that we are really delighted to have with us Dame Sian Elias. She was the very first person I thought of and the first person I invited when it came to having this session, because she really has had an extraordinary career as a judge and as a barrister, and has a great depth of feeling for the task of adjudication, which I hope that this conversation that we're going to have with two of her countrymen is going to illustrate for all of you here today. So David Williams, who's an eminent professor from New Zealand, and Max Harris, who is about to be an eminent New Zealander, who is a DPhil student at All Souls, and who is a commentator on New Zealand public affairs, will really put the questions to Sian, but there will also be opportunities for all of you to put questions as well. So just for those of you who aren't aware of Dame Sian's career, she is the 12th Chief Justice of New Zealand and the first woman to be appointed to this office. She graduated from the University of Auckland in 1970 and was admitted to the New Zealand Bar in the same year. She also holds a master's degree from Stanford University. She's had experience both as a solicitor and a barrister, but mostly as a barrister in her later years. She's been a member of the Law Commission in New Zealand, where she worked particularly on company law. And in 1988, she became Queen's Counsel. One of the issues that we're going to explore in the conversation is her experience of working with cases underneath the Treaty of Waitangi. She's had extensive experience on that, and I think that one of the issues around the Treaty of Waitangi is that it illustrates the difficulties of pluralist legal systems as well as the opportunities of them. And I often think that the New Zealand approach to the Treaty of Waitangi has been a great example around the world, and certainly was an example that South Africa drew on at the time we drafted our land claims legislation in the period leading up to the first democratic elections in 1994. Dame Sian has also sat as a member of the Privy Council and was indeed the last Chief Justice it's been during her period of Chief Justice that the appeals from the Privy Council have come to an end and the New Zealand Supreme Court was established, and she has presided over that court since its establishment. So I thought we might start off, Dame Sian, if we could, by asking a question I often get asked. Sian, okay. By asking a question I often get asked, which is, how is it that you came to be a judge? Can you tell us a little bit about key moments in your career, or when it was that you thought that, in fact, you might like to be a judge, perhaps if you have even had that thought, and whether you might still have it?
Well, I'd love to be a time traveller and go back to legal system 1966 to tell my classmates that one of the female member of the class, because I was there were 4 of us in the class, would be Chief Justice, because I think they would have fallen around laughing. So it's really hard to go back to that time. So I certainly didn't have any idea of being a judge, and it was hard enough trying to practice law. It was very difficult getting a job as a female in 1972 with my shining new degree from Stanford when I came back to New Zealand. So I really went to the bar pretty soon after I'd had children, because nobody was going to employ somebody with a family. So I blundered into all of that, and then in the way that it's an ill wind that doesn't blow some good, I ended up doing work nobody else wanted to do, and I tried to and some of it became really quite significant work. So I suppose I had a profile, and after that they were very keen to appoint women. And so I was the second woman to be appointed to the High Court. But personally, I went on the court in order to practice law, because I still wasn't attracting the range of work that I was interested in doing. And even though I did do the company law reference, and I thought now I'll get some company law briefs because the Act picked up the suggestions, but I never did. So I did a lot of public law cases, which I would probably not have done, and it was very enriching. And I did muck-about work as well, crime and whatever was going, some family work and so on. So it was not a strategy to become a judge.
Yes, yes. I think for many of the first tranche, as it were, women judges, that has been the case. They didn't ever imagine that they were going to be judges.
No.
Sort of life changed. David, can I hand over to you?
Well, so you and Max and I have sort of dreamed up some questions. Sian has had a vague idea what they are, and I'm expecting Sian to just draw on her experience and hopefully by now wisdom in offering some thoughts to this audience, which is familiar with the fact that there are only one or two countries in the world that have what some people call an unwritten constitution. Of course it is written, but it's written in lots of different places. Unlike
Partly written.
Partly written in lots of different places. And you've spoken on numerous occasions, extrajudicially as well as in your judgments, to the effect that that constitutional arrangements gives a great deal of burden, in fact, on judges as to how they interpret constitutional issues when they come up. So would you like to think about that out loud with this audience?
Well, you don't have the legitimacy of a text that you can point to. And I think perhaps because of the familiarity that the world has with constitutionalism under the American model, that tends to mean that people don't think you have a constitution. In fact, it's quite common in New Zealand to have people express disbelief when you talk about the New Zealand Constitution. So we don't have a developed constitutional sense, I think, as a country, which means that when there are issues which do touch upon constitutional fundamentals and you have to explain them, it's very difficult for it not to look like a power grab, and it's often characterised as that. So I think it's quite a... I'm, in fact, a fan for not having a text because you're not imprisoned by the text. Although I have been wondering recently whether we can afford to have such an opaque foundation because it's very difficult for people to sign up to it. It's very difficult to have a community that coalesces around principles that you can all subscribe to. And I think in a society like ours, which is changing very fast, huge immigration from backgrounds where if you say to them, well, you know, Magna Carta, well, they just look at you glazed. In fact, I said that to one of my friends the other day, and he said, but if you said that to any New Zealander, they'd look, a glazed look would come across if you spoke about it. So I think it does leave the judiciary very, very exposed in talking about constitutional issues on and off the bench. When I was appointed Chief Justice, Sir Geoffrey Palmer, who was a former Prime Minister of New Zealand, said to me, you know, you're just going to have to go around the country talking about the Constitution because people don't think we've got one. So I have always tried to do what Geoffrey told me to do because it's much easier. He's a rather sort of powerful person who shouts at you if you don't do what he likes. So I've done that, but of course it has got me into quite a lot of trouble because people think that I'm talking up the judicial role, which I don't think I am, really. But anyway, I do think that there is a big question. I'd be interested in what the two of you think about that. We do pay a cost for not having an accessible statement of what we believe in, I think.
Well, Jeffrey Palmer has now given us a document.
No, he's given us one.
Which he wants us to adopt.
It's very
Do you have
boring.
any thoughts on that?
Well,
it's very boring.
no,
We've
don't
got to
tell
avoid
Jeffrey that.
What do you reckon, Max?
I think it's good that there's a model out. So yeah, Jeffrey Palmer, with a New Zealand lawyer, has produced a book called A Constitution for Aotearoa New Zealand. And do you think it's helpful to have a model out there to debate?
Yes, but nobody's debating it, which really, again, buys into the problem we have, that no one's really very interested in constitutional fundamentals, except judges who bang on about it all the time.
But we are interested in rights adjudication, which is what Kate's interested in this institute. So you've got to have some background for your rights adjudication.
Yes, you do. We are, but I'm not sure how far it goes.
So, I mean, just taking the New Zealand Bill of Rights Act, I mean, to what extent do you think that has become seen as part of this constitutional framework that partly determines what the different branches of government are about?
It's really hard to say. It's really hard to say how it's perceived in the community. People do talk about rights. When I go around the Pacific sometimes, I'm always struck by, if you're talking about cultural issues, culture and law, there is no doubt that people are not willing to surrender what they see as their universal human rights, particularly women. And so I suppose it depends where you are in a society, how motivated you feel to enter into that discussion about human rights. It's very hard, sitting where I sit, where the cases come, to know, though, how much support there is more widely in the community for our Human Rights Act. What do you two think?
Well, a little bit like students in your class would have been surprised to have known the woman could be appointed Chief Justice. People who looked at the New Zealand Bill of Rights Act when it was first passed would be surprised to know that it could be used in the way it has been in the recent years, because I mean, I know Bajan is a little bit of an exceptional case. You might like to expand on the way in which the judiciary is, in fact, in a sense, constitutionalised the Act. It's not just like the Dog Act. It's got some higher status, and what does that mean?
Well, I don't know that we've ever really bought into the Dog Act. I was looking the other day at the uses of Henry VIII clauses, and I was in New Zealand, and I was very interested to see that there's a Dog Control Act that has one that was enacted about 2 years ago. I thought Dicey would be interested in that. But I think we have... It's difficult to know to what extent it's been led by a small group of people, but we have had legislation, for example, which has created a category of, or has recognised a category of constitutional statutes. So our Imperial Laws Application Act, which uses which collects together some of the written bits of the Constitution, which are also the English written bits, which we've inherited. It groups the Act still in force, the old statutes still in force in New Zealand, the English ones, and they are grouped under different headings. And the first one is constitutional provisions. So I think people do, but whether that Act, of course, was the work of Sir Kenneth Keith, one of our eminent jurists, and Jeffrey Palmer. They cooked it up. And they are also the people who are responsible for our Freedom of Information Act, our Ombudsman Act. So there was a time when we had a group of people who were really thinking about the Constitution and who were in a position to do something about it. I'm not sure how far that how that whether that continues, and whether there are people. I don't get the impression that in our Parliament people talk about the Constitution very much. I might be wrong about that. I don't think they talk about the rule of law as much as I'm told the British Parliament talks about the rule of law. But it's one of the reasons why I think it is important to keep talking about it. It is the thing about a constitution that doesn't have a single text that you can access, that you do need to keep talking about the constitution because it's an evolving thing.
I was going to ask you about comparing the British experience and the New Zealand experience, because for those of you that don't know, New Zealand has a statutory Bill of Rights that was passed in 1990, quite similar to the Human Rights Act, but without express provision for declarations of incompatibility. And I just wondered, how do you think New Zealand and the UK's experiences compare? Do you think there's been more of an embrace of the Human Rights Act in the UK as compared to the New Zealand Bill of Rights Act 1990?
Yes, I do. I think that's probably under the shadow of Europe. I'm personally disappointed with the use of our Bill of Rights Act. I think there have been a few missteps along the way. It's much better having it than not having it, because you do have democratically conferred principles which provide a register for judicial reasoning, and also I should hasten to say that I think the real effect of the New Zealand Bill of Rights Act has been the impact it has had on government. So I think when I say I'm disappointed with it, I think there's no doubt that it has transformed the processes of power, and that so I think that the people in the public service take it very seriously indeed, because it is accessible. And if you don't have that, you have what? A principle of legality, presumptions of common law values, which have to be identified by judges, which sets up the power grab notion. We can say, well, there they are. And of course, in any event, it's our international obligation. So I think that the Bill of Rights Act, I don't want to say, when I say I think I'm a bit disappointed with it, I just feel that there were some opportunities that have been missed in that. I think that we've made insufficient use of the interpretive provision. I think it is a provision of general application, like in the Human Rights Act, the UK Human Rights Act, but it is it's very common to see practitioners not thinking about using Section 6. They'll always go to the Interpretation Act, but in fact our Section 6 is yet another principle that should always be trotted out when you're looking at statutory interpretation, and it's not. I don't myself think it's a weaker form, even though it's been said that the Human Rights Act UK is a stronger one. But our judges are told that if a provision can be given a meaning consistent with the rights and freedoms in the Bill of Rights Act, it must be, and that seems to me as strong as yours as well. But I'm also very disappointed by what I think of as the Section 4, 5, 6 dance, which is that there was a debate in New Zealand when we brought in the Bill of Rights Act between two of our very senior and highly respected judges about whether, because we brought in a general limitation like Section 1 of the Canadian Charter, that the rights and freedoms are subject to such limits are prescribed by law and justifiable in a free and democratic society. And there was a debate between them as to whether, when you come to interpret provisions consistently with the Bill of Rights Act, they are the provisions unmodified, or whether they are provisions which are with limitations which are justifiable in a free and democratic society. In other words, you do your reading down first, your balancing first before you interpret. That's had two, I think, undesirable outcomes. First, that we erode rights quite readily, I think. And secondly, and that eventually was that approach was taken in a case called Hansen in the Supreme Court, in which I was in dissent. So, this is not sour grapes. I actually think it was not a right step, and I don't think any other country does do that sort of sequencing. And the other reason I think it's very bad is because it lets Parliament off the hook, because we too have a provision which I think is now picked up in a lot of the so-called Commonwealth models, whereby the Attorney-General has to report to Parliament if proposed legislation is inconsistent with the Bill of Rights. And since the decision in Hansen, the Attorney and the Ministry of Justice take the view that there is no need for a report if a limitation, in their opinion, is one that is justifiable in a free and democratic society. Well, I would have thought that that was very much a matter for political judgment, that the politicians should be taking, or the Parliament should be taking that responsibility. And instead they're not even told, because some often quite junior lawyer in the Ministry of Justice takes the view that the limitation is justifiable. So I think that that is really very bad.
Could I just follow up on the interpretation question, because this has been quite an issue in South Africa. So often what happens is that the clause comes up for interpretation in a case where there is not a constitutional challenge to the validity of the clause.
Yes.
And of course, it's only if there's a constitutional challenge that the state is on notice to produce, it bears the burden of establishing that it's justifiable under our limitations clause, that it would then produce the evidence. So you get a situation where you know that the interpretation of a clause is a constitutional issue, but in fact you may not even have a member of the, there may not be, the state is present at all, and in fact there isn't a constitutional challenge, so you can't really join them because they don't have a direct interest. So what we've tended to do there, and it's tricky, is to say, especially where the clause is capable of several interpretations, is to say that we're adopting a particular interpretation, which will normally be the most rights consonant one, but we leave open the point that this is not an issue that has been yet considered under a constitutional challenge, and there may be grounds of a justification that may arise. And that, so in other words, it's an issue going to precedent, that in fact the precedental value of the interpretation may be not that weighty if there is a direct challenge to the provision. It's tricky though, because of course once you give it the rights interpretation, the prospects of a challenge go away. So you kind of feel that by doing that you're removing the possibility of a challenge, because the people who challenge are going to be wanting a right strong interpretation. And it's always left me with a feeling of discomfort when you give an interpretation where there are various choices and Parliament hasn't actually had an opportunity to present justification. That obviously is slightly different in New Zealand, where you wouldn't ever have a constitutional
Well, you
challenge.
never have a constitutional one,
Exactly.
and we would always give notice to the Attorney-General. Yes.
Whatever
Yes.
the case is.
And if it was arising if a Bill of Rights Act issue arises even as between two private litigants, we would give notice to the attorney, who can decide whether to intervene or not.
Right, that's interesting. Yeah. In South Africa, that could be almost every case that comes before the courts because of the breadth of the Constitution.
Yes.
Yeah.
Related to that, you have been surprised, haven't you, before that Section 6 interpretation arguments haven't been run in some cases.
Absolutely.
For example, in criminal cases, that is, the Bill of Rights Act hasn't been used to reinterpret, in one view, criminal law legislation.
Yes, I mean it's used more in criminal cases than in anything else. My surprise has been that the profession has been so slow to pick up on the Bill of Rights Act in other litigation. I've had people arguing in civil cases access to justice points, or they're bringing civil claims against the state, and they very often will not refer to the Bill of Rights Act. And you know, you can have a lot of fun saying to them, but I'm surprised you haven't mentioned Section 23 of the Bill of Rights Act. And these commercial lawyers look absolutely aghast because they've never ever looked at it. In fact, I did have one senior Queen's Counsel when I raised this, saying, "Well, now that I am reminded of it, and he must have caught my eye. Now that I read it, it is not unhelpful."
So, most of the people in this audience will be familiar with Bill of Rights types of arguments and Human Rights Act arguments, but one of the distinctive features of New Zealand jurisprudence in recent years has been the role of the Treaty of Waitangi, and when the Supreme Court Act was passed and abolished the appeals to the Privy Council and set up the court that you've had the honour to preside over for its whole existence thus far, there's explicit reference to...
Will be free of me soon.
Well, we haven't announced that part. Anyway, legal matters relating to the Treaty of Waitangi to be resolved with an understanding of New Zealand conditions, history and traditions. So how much impact do you think, your own experience in Treaty of Waitangi litigation before you're on the bench, and your experience conversing with your colleagues on decisions which have a Treaty of Waitangi element to them, what's your sort of assessment? How well have we done in the courts thus far?
I think there is a willingness to be open-minded about the impact of the treaty in all sorts of cases where only a few years ago it would have been thought unthinkable that there would be a treaty dimension raised. I think my colleagues are very open to that sort of thing. We have come a long way awfully fast in New Zealand. When I was involved in treaty work, because as you know, nobody wanted to pick it up. This man is really to blame for it, because he rang me up and told me that one of the Māori women he knew was taking a case to the Waitangi Tribunal, and could probably do with a bit of legal advice. So I turned up for the Manukā hearing, thinking that I'd sit at the back and every now and then would... And I read for the first time the text of the Treaty of Waitangi.
Because neither you nor I had to talk to us when we went through our law school.
Never. And I mean, I'd done my dissertation at Auckland Law School on whether we should have a Bill of Rights Act. I decided no, we shouldn't, because, you know, it would be contrary to parliamentary sovereignty. But, you know, that's I always feel that the people who are most attracted to positivists are the positivist thinking are immature. And I grew out of it. But anyway, so I hadn't read the Treaty of Waitangi. And when... Just a few years on from that, I was asked to give a talk to the Legal Research Foundation in Auckland. There were about 80 lawyers, I think, there. And I asked for a show of hands on who had read, this was probably 1985, who had read the text of the Treaty of Waitangi, and not one hand went up. So there's been a revolution. and a lot of that was because the Waitangi Tribunal was set up, and it provided a bridge to understanding. It had the second chair of it, the first chair was less successful, but when Eddie Dury was appointed to it, he was a very good lawyer, and he was able to express what the issues were in ways that were recognisably law, and that provided insights for the courts, which they could use when some of these issues arose. And then, of course, it came at a time when the government was restructuring and trying to divest itself of its land holdings, the fisheries resource, everything else. And so litigation was brought to stop these assets disappearing into private ownership before the treaty claims to the Waitangi Tribunal had been processed. And I was involved in those, and we stopped that major government initiative, and it has had a huge effect, because from that has come the treaty settlement processes, which have ended up with enormous transfers of assets to iwi tribal groups. And it's a very different scene, isn't it?
It is, and so more recently, the Supreme Court jurisdiction, has it had much impact on your thinking?
We've had a number of significant cases in that court. I think it has had. I mean, I did a lot of work for Māori people, so I do have a number of insights into, I suppose, the background of grievances, which I'm sure has helped me in some of those cases. But if you think about, say, the Mighty River Power case or the Takamori case that you were mentioning earlier, I think they have been quite significant.
So I think Kate was quite keen on you to say a
the
bit more about
Takamori
Takamori case. So perhaps the rest of the people could join our conversation.
Yeah, the was a case of a Māori man who had married a Pākehā, a non-Māori. They'd lived in his quite remote tribal area. It was Whakatohia in the eastern Bay of Plenty, which is quite remote really, and had Tūhoe connections too, which are even more remote tribal group. He has clearly, I think, the wife had not been happy living in that community, and she left with the child, and he followed, and decided that, and they lived in Christchurch, and for 25 years they lived in Christchurch, and there were a couple of children born to the marriage. He stayed in touch with his family, but it was remote, and he went back for when his father died and so on. He died, and the family from Whakatohia came to claim the body to take back to Whakatohia to the area to bury, where his Pito, his afterbirth, was also buried. And so culturally that was extremely important. And there was a bit of a standoff between the widow and her children, who knew nothing really about that side of their father's life, and the family from the coast. And eventually there was a little bit of a misunderstanding, I think, and they took him back and buried him. And so this was a big issue, and it was very badly presented by the press as body snatching, and we'd had a couple of other cases. In Māori cultural terms, it is honour that you do to the person to care enough to take them home. And it's very important for that person to be back with their ancestors. And very often, husbands and wives go in different directions, particularly if they're important people. So, I mean, I knew all of that. I was quite sad when the case came to us to see how it had been dealt with in the lower courts. There was some quite insensitive comments that had been made, just through ignorance, really. The Court of Appeal had said this was an example of unlawful exercise of might is right, and there were one of the judges in the Court of Appeal thought that there would be an action in detinue for having taken the body, and so there were all these sort of and it was actually potentially quite an explosive issue, I think, within the community. Anyway, I think I don't know, I would say this, but I think the Supreme Court handled it much better. The result was that the widow, well, it was also interesting in terms of how the common law was viewed, whether Maori custom would be adopted by the common law, because of course the common law was adopted in New Zealand only to the extent that it suited New Zealand conditions. So we have a continuing issue about the extent to which the New Zealand common law diverges from English common law because of New Zealand local conditions. So there was a division in the court. The majority took the view that there is a presumption at law, even taking into account Maori custom, there is a presumption in New Zealand common law that the executor, and the widow was the executor, determines the place of burial. I don't think, I dissented because I don't think actually the law is that clear about whether an executor has the right to determine the place of burial, but we all agreed that because of the choices that he had made in his life, the widow and her children, and who didn't feel comfortable with with his family and with him being buried there, should have the right to say in this case. But afterwards, as I had hoped, but we said a lot of things, I think, that healed some of the wounds, and afterwards they did come to, there was a mediation and they came to an agreement. I don't know what the agreement was because it was confidential, but...
it's still confidential, but you are allowed to mention that there was a High Court judge that was involved in helping the mediation.
Oh yes, one of the High Court judges helped him. Yeah.
Just a couple of background questions for context, perhaps. You mentioned having knowledge of those Māori concepts, and you talked a little bit earlier about doing work for Māori. Could you say a bit more about how you were drawn into representing Māori in your earlier work, how you came to learn a little bit about tikanga Māori concepts?
It was because I didn't get any of the sort of work that I had hoped to get. So it did enrich my life that I didn't get to do those commercial cases, really. So I was doing some criminal work, and I ended up defending some students who had had a fight with the engineering students who kept performing mock haka, the Māori dance, at capping parades with obscenities daubed across their bodies and harassing women. And for 10 years, the Māori students had been saying, don't do this. It's very offensive to us that you treat our culture in this way. And eventually, some of the more bolshy ones, who I now see in airline lounges because they're very respectable, went and there was a fight, and they were charged with rioting. So that was a really interesting case because the whole of the Māori world really came together over that. They didn't condone what these young people had done, but they were deeply shocked that this should have been going on. So we had wonderful old Māori men and women who came and talked about what this meant in their culture. Had evidence. They gave evidence in Māori. It was the first time that Māori, I think, had been heard in a New Zealand court for many years. And I wasn't sure that the magistrate, or was he a district court judge at that stage? I can't remember. District court judge.
In the 1970s, 78, wasn't it?
78 it was. I wasn't sure whether he would allow us to call evidence in Māori, particularly as the elder who was giving this evidence was, of course, fluent in beautiful English. But it was a terrific experience, and through that I met some of the Māori leaders who then asked me to help with various cases, and then I got into the treaty work with David telling Ngāneko Minhinnick that I would help her. And of course, as soon as I turned up at the Waitangi Tribunal hearing, expecting just to have a bit part, the tribunal was so delighted to have a lawyer there who could try and organise things that they pulled me forward into the front row and got me to call the evidence, which was awful because I couldn't even pronounce Māori. I was mangling all the names, but it was a fascinating experience. I mean, do you remember young Carmen Kirkwood? Yes. Standing up and saying, with tears rolling down her cheeks, I mean, we all thought it was preposterous. People of my background had never heard that there were these grievances. And Carmen Kirkwood, I'll never forget her, standing up and saying to the tribunal, you know that it's I blame, she said, our old people, because they knew that on the marae, you know, in the meeting houses and things, these grievances have been talked about, these claims have been talked about always, but they've never taken them off. They've never, in recent years, they had never gone outside and said these things, and it was very moving. So then I had some cases involving rivers and mountains and things like that. It was incredibly creative legal work because we didn't have any texts. Nobody had written about these things. We were looking for ideas wherever we could find them. Flipping through the old ordinances of the 1840s, which is actually a really good thing to do because it jogs a lot of ideas. Reading texts on jurisprudence, discovering that all sorts of weird things had happened in the Privy Council in the 19th century. One of the cases we had was about, because they kept saying, you know, this is about a case about the Wanganui River, in which the claims had been before Parliament and the courts since the 1860s. And they kept saying, you know, but we don't want to own the river. That's not the right relationship. The river is an ancestor. So we discovered, you know, by accident really, references to a Privy Council case from India in which an idol was recognised as having legal personality and could own property. So we ran the argument that the river should be recognised. Well, this year they have. It's taken a heck of a long time, but it was a bit frightening looking back. It was sort of pretty freewheeling stuff, and it was very hit and miss. But it did teach me a lot about legal techniques, about how you can look for ideas and just think about how they can be applied.
Just one more general question on this. I think not everyone will be familiar with the Treaty of Waitangi. It was often said, it was said by some historians that the treaty was inconsistent and contradictory across the English and Māori texts that were signed in 1840. I think I'm right in saying that you developed an argument, or you described how the treaty could hang together, and I think that speech to the Legal Research Foundation conference that you mentioned. I wonder, could you just explain what you said there and to give some background?
The treaty has, well, David's really the expert on the treaty, but the treaty has 3 very simple clauses. The first one, this is in English, but in fact the Māori is I think, wholly comparable, but that first sovereignty was ceded by Māori to the Crown. Secondly, that Māori were guaranteed in their properties, and in the Māori version, that is, they were guaranteed te tino rangatiratanga, which is the highest chieftainship of their properties, which I think almost certainly was to convey to them that they could continue to govern their own properties. And then the third article was that Māori were granted all the rights and privileges of British subjects. So that's the terms of the... that was another slightly offensive thing, I think, that in the Takamori case in the High Court, it was said that it was inconsistent with Mr. Takamori's Article 3 rights to be a British subject, that he shouldn't be able to be free of his culture. I mean, that was offensive on a couple of scores, but the worst one being that I don't think there was an indication that he really... and it was very upsetting, of course, to the family to have it said that he'd turned his back on his Māori culture, and there really wasn't evidence of that. He'd clearly decided that his life was worth his partner and his children, but that didn't mean he was repudiating his culture. So that was an Article 3 application. We haven't had many of those.
Do you want to keep going, Max?
Sure. I mean, I was coming back to Takamori, I guess there's one critical response to the case, I think, from Claire Charters was that...
A Māori academic.
A Māori academic was that a non-tikanga institution, the Supreme Court of New Zealand, was deciding tikanga matters in that case. And I think she acknowledged that your judgment was particularly sensitive to those issues, but that there were real risks involved with judges from different cultural backgrounds deciding on matters Māori, and I just wondered how you'd respond to that.
Well, I think that there is validity in that. We've always had provisions in our legislation that Māori custom is to be ascertained by the courts as a question of fact on evidence, and that also the High Court has the ability to refer matters to the Māori Land Court and Māori Appellate Court, I think it is, Māori Appellate Court, for an opinion on that. So we've got mechanisms for an authentic assessment of what tikanga requires. But as to whether it should be kept apart, I do think that the reception of the common law was subject to local differences, and I think Maori custom is one. I think one of the problems that Indigenous people often have is that as soon as you talk about custom, people think about British law and custom being immemorial and not able to be changed, whereas this was a living society which had governmental attributes, as the British recognised at the time during the 19th century, and so it has to evolve. Well, if you have an evolving custom to which you give effect, I think that's common law. It's part of the common law. You have to recognise it like that. Otherwise, it seems to me it becomes an artefact. But I recognise there are different perspectives on that.
There's one other thing that strikes me about takamore, and that is that it touches on, underneath it lies this really complicated and intractable question, I think, in pluralist societies, which is what is the basis for determining which system of law applies to whom? And is this something that is a matter of choice, which of course is a sort of general liberal democratic understanding of the nature of how we decide, or is it a matter of heritage and who your ascendants were and what your background is? Is this an issue you think that is likely to arise regularly in New Zealand, and do you think that there is any answer to that question that can apply across a string of cases, or is this something you're going to have to look at depending on the nature of the case, the nature of the issue, and the individuals concerned?
Well, I don't expect it to be to crop up often. I don't. But I do think it is inescapably a case-by-case assessment. If I think I said in takamore, ultimately it'll have to be resolved by the courts if people can't. That's what they're there for. But it's not. This sort of thing has cropped up in other jurisdictions. In Australia, there have also been burial cases. In fact, there's a very striking example of twin brothers, I think they were, but anyway, brothers, and there were disputes about where each of them would be buried. They didn't die at the same time, but they died quite close in time, and the courts went into it about where they what they had indicated. There wasn't a question of simply imposing any sort of fixed rules. And indeed, I don't think in terms of burial, there are Māori, tikanga is not really fixed. It's a question of debate and adjustment. And so I think it's reconcilable. I think there are, it's then a process, and it's a bit, I suppose it's sort of judgment of Solomon sort of stuff. Are you going to cut the baby in half, or are you going to decide who is going to be, who cares the most, perhaps? And maybe you just have to work it through like that, as I think we did in takamore in terms of the all the elements there, although we came to different views, but that'll happen too.
So, Kate, get some guidance from you. I mean, we've got some rich pickings,
yes,
and we've got one or two more questions, but do you think perhaps we should open it up?
What we might do is open it to the audience, and if there are further questions from the panel, we should go ahead there. But are there questions that people have? Yes.
I'm Laura Hoyana, fellow of Wadham and also practicing barrister. I was curious about the actual jurisdiction of the Maori court and the appellate court which you mentioned, and in particular whether they have any criminal law jurisdiction. In Canada, where I originally practiced, we have sentencing circles, which after a plea is entered, if there's a guilty plea or a conviction, the case may be remanded to the tribal sentencing circle to actually impose a sentence. So could you describe a bit more about how the Maori courts work and whether they work together with the, I'm not quite sure how to put it, but the general courts that are applicable to all New Zealand citizens?
The Maori Land Court is a land court only. That's right, isn't it? They haven't given them more... they might have given them family protection jurisdiction more recently. But that's a succession issue anyway, and it's probably only in relation to Maori land. There has been a recent amendment. So it's land only. And also it can resolve questions of tikanga on reference, as I mentioned, from the High Court. So there have been times when we've had more pluralism in New Zealand criminal law. For example, at the very beginning, because of Maori abhorrence of imprisonment, for theft, they were not to be imprisoned. There was a specific legislation. There have been minor tribal, not tribal, but the Maori Affairs Act had some minor matters that could be resolved in that forum. But in criminal cases, it's just the general courts, but we have had an initiative in recent years to set up rangatahi courts, youth courts, where the youth court jurisdiction is exercised on a marae and the judge sits with some senior elders as part of it. But that is not comprehensive. It's I think it's a pilot really that is being progressively rolled out.
It has been piloted, however.
It is being piloted. But it doesn't lead to different results. It's just the youth court, but it's...
Timothy and then Aileen.
I was really interested in what you said at the beginning about power grabs and the way that constitutional arrangements in New Zealand might make something look like a power grab, and I think you were implying that it might do so when it wasn't a power grab. And let's say that's a wrongful articulation by the judge of his or her own power. And of course you could say the same about English constitutional history. But it must be possible for a judge to wrongfully extend his or her reach. And I wonder what you would count. I'm not asking for a code of judicial impropriety, but your sense of what would count as a judge in this remarkable constitutional situation, articulating his or her power in a way that they shouldn't have. And has it ever happened in New Zealand, or would we have to go to India or the United States to find it?
To find overreaching? No, I think you find overreaching not often, but you find it in all sorts of ways. Judges or not observing the law, that's really what appeals aim to correct if they do. But I do think it is, if a case is properly constituted and comes before a judge, the judge has to decide the case. It's an obligation. It's not a power grab. And some of these things are extremely difficult to determine. I suppose, I mean, an example of perhaps what is much more debatable is we were talking earlier about declarations of, it was before we started, was it? Declarations of incompatibility, which our Bill of Rights Act doesn't provide for. And I think there's a case coming up to us through the system at the moment, although there have been indications in the Supreme Court that, not from me but from some other judges, that it doesn't seem to be a big a big call. I think that could be said to be, if it's given as a remedy. I mean, there is a point at which, if in your reasoning process you have, particularly on this dance of Section 5, 6 and 4, because Section 4 is the provision that you have to apply the legislation if you can't interpret it inconsistently. But because of the way we now always look at Section 5, is it a justifiable limitation? You are actually expressing, in that methodology, you are expressing views about whether a limitation is justifiable in a free and democratic society before you get to Section 4, which requires you to apply it nevertheless, because you have to get there in order to then do the interpretation thing. So, I mean, I think that's really bad methodology, but it does mean you are saying that something is not compatible in your reasoning. And, I mean, whether you say, I declare, and give it as a remedy, I'm not sure that it really matters hugely. It might in terms of costs or something like that, I suppose, or if you want to be... There could be... I can't think that it does matter very much. Sorry, does that answer or not?
Lily, thanks for a great conversation, and actually my question also follows from this idea of power play, and I'm wondering if you would just say a bit more about the kinds of accusations that are made and from whom, because the perception here in the United Kingdom, when comparing the Human Rights Act and the New Zealand Bill of Rights, the perception here is that maybe what explains the difference in mode of interpretation, in other words, the more adventurous interpretation here, broadly speaking, and the more conservative in New Zealand, is political culture, that within that political culture it's not deemed acceptable. But in the United Kingdom, the criticism of the courts under the Human Rights Act has been the adventurous use of Section 3. And so accusations of power play come because of these adventurous interpretations. And I didn't know whether in the course of your conversation, whether you mentioned that actually you thought more adventurous interpretation was appropriate. And the second related question was, if you like, the flip side of power play, because I was struck when you spoke, and I say this as someone who also comes from a small country, you know, who comes from Ireland, where everybody knows each other, and this came across in the conversation, you know, that you knew Jeffrey Palmer, and you know, you see people in airport lounges, and you will have gone to the same university together, and so on. Are there ever, so you will know people in Parliament, there will be relationships there. Are there ever accusations of the opposite of power grab, but aligning too much with the political branches? And so rather than usurping their role, which is the accusation here in relation to interpretation, that you're not asserting the judicial role strongly enough, but you're too, and I don't say this as someone who knows, I apologize about the jurisprudence, it's just an open question.
Well, I think the culture doesn't encourage judges to be bold. Now, I don't think judges should be encouraged to be bold, because I mean, you just have to. It's just a job, you know. You have to. You're not there to, as they keep telling us, to set the world to rights. Well, I don't think any judge really thinks they're there to set the world to rights, but you have to respond to the issue that you're dealing with. But I do think that it's a small society. It used to be a pretty egalitarian society, so they probably don't like people who put on wigs and gowns, which is one of the reasons I'm desperately trying to get rid of. We only wear them for ceremonial occasions, but I want to get rid of them. Because
some of your colleagues aren't so keen.
Yeah, well, too bad. there's got to be some perks of being Chief Justice. And I'm going to get rid of those spaniel's ears if it's the last thing I do. But actually, we are working on a ceremonial robe. Frankly, we shouldn't even have ceremonial robes, but I can't. It's going to be easier to do that. Sorry, what were we saying?
It was about power grab.
Yeah. Well, so I think I think we have and if you have a society where you have a very obscure constitutional arrangement, then if you talk about things being fundamental or something like that, people feel a bit disturbed about it, and they want to take you down a peg too. And it hasn't helped that we've had some very, very difficult academics. Well, I was thinking about people like Jim Allen, who luckily has gone to Australia, but still gets and harasses the judges there mightily, but still gets published in the business press in New Zealand. It's just a rant, really. Oh, I suppose it's defamatory. Rant is such an opinion. Free speech.
Could I jump in there?
Yes, of course.
I think one of the areas of controversy around power play in New Zealand has sometimes been around judges speaking out extrajudicially.
Oh, yes.
And I think you've given some very far-reaching speeches on topics like prison and legal aid and the treaty. And I just wondered how you see your role in extrajudicial speaking and the limits of that.
Well, I don't think I've said too much
in
those contexts. You do. It is part of the obligation as Chief Justice, and I do think Geoffrey Palmer is right. I mean, who is going to speak about these issues if people like me don't? I don't think I've rammed ideas down people's throats too much, but it just seems to me to go with the territory, really. But you're right. I mean, one of the things that I did get into trouble with was the thing you were talking to me about earlier. I wrote a paper on parliamentary sovereignty only because I was really revisiting what I'd done in my dissertation. I wanted to
moving beyond your legal positives.
Moving beyond that, and it was Cheryl Saunders, who's an academic I very much admire at Melbourne University, asked me to go over and speak. So I did this. I was shocked really at the response. The Deputy Prime Minister gave a speech which I read the other day, because at the time, you just let it wash over a little bit. But I know it was written by a speechwriter because the speechwriter told me that he had written just a small society. And I was shocked at how it filleted what I had said, didn't contain any of the qualifications, and put a very different spin, and it was just done really for political effect. But anyway, that was.
So judges had invented parliamentary sovereignty, but judges could contain it.
Oh, I don't even think I said that really. No, all I was saying.
That's how it was presented.
Oh, that's what they were saying. All I was saying was that I think it's a terrible shame in terms of the conversation we need to have as a country about the Constitution, that we have this showstopper of the quest for the power that trumps every time anyone talks about the Constitution. We don't have one principle, which is our Constitution, which Michael Cullen was saying. He says we have parliamentary sovereignty, that's the be-all and end-all of the Constitution. Well, it's not. And so I'm quite unrepentant about what I said then, but it's interesting that people don't like you talking about the Constitution.
Thank you. Megan.
So without their
entrenched Human Rights Act in the UK, there's a periodic and maybe active debate about scrapping the Human Rights Act and just replacing it with something else. I'm wondering if the same debate exists in New Zealand, and if it does, what context it arises in, or when. Is there any trends that you could see about debating, or should there be either an entrenched Human Rights Act or even getting rid of the Human Rights Act that does exist?
Well, I don't think there's any appetite to entrench it or introduce judicial review of legislation or anything like that. So that I don't think that will happen. But on the other hand, I don't think there's any move to get rid of the Bill of Rights Act. I mean, it's our international obligation, and I think people accept it. So it's really hard for an outsider to know what on earth they're going on about in the UK about getting rid of the Human Rights Act, because they've still got the ICCPR. You know, what's going to change, really? I suppose what will change is that it won't be subject to the European Court of Human Rights, but they better be careful what they wish for, because the UK courts could be quite strong with it. I would have thought, but I don't know.
Yes.
I'm fascinated, and I think it's wonderful that you're in this situation where you have the opportunity to educate people about sort of this, as I gather, somewhat amorphous constitution. It's great. It's a great opportunity and a great responsibility. But I do want to ask you, though, about the relationship between what I would refer to as the civil courts and the Maori courts. So, for example, are the decisions of the Maori courts reviewable in the civil courts? Are there instances when issues arise among Maoris that the civil courts can take jurisdiction, or do you have a rule where the Maori courts alone exercise jurisdiction?
No, they're not. They all come together under the High Court, which is really the basis of our constitutional arrangements. Because the High Court has all the powers of the courts at Westminster, it has the inherent jurisdiction. I mean, if there's a worry in our constitution, it's around judicial review and erosions of that. But so the High Court judicially reviews the Maori Land Court and the Waitangi Tribunal, and there are appeals from the Maori Appellate Court also to the Court of Appeal, although they're hardly ever used. But I mean, we've recently had a case in the Supreme Court where the Waitangi Tribunal was refusing to exercise jurisdiction because it was a case where there were conflicts between two groups of claimants. And we have a system in New Zealand where the government is settling treaty claims, and it has a pretty slick process for doing that, which means it will only deal with the big iwi group, the big tribal group, so that if you have distinct sub-tribes with particular grievances, they say, well, you know, it'll have to all come out in the wash, which is very disappointing to a number of those applicants. And then you're on a track whereby you get where the Waitangi Tribunal won't go on and complete its inquiry. It will simply make findings of fact, and it won't make recommendations for relief, because generally speaking it doesn't have the right to impose solutions. It only makes recommendations, but it holds back even from that and says, now go away and talk to the Crown and settle it. And once there is a settlement with the bigger iwi group, it gets legislated into effect, so it cuts off any rights. And we had a case where the Supreme Court directed the Waitangi Tribunal to hear and determine, to the extent of its jurisdiction, a claim by a smaller group, which clearly the tribunal would much rather not have done, because it's actually in the process of, it's now in the business of being part of the settlement process. So we said, no, you have to go and do it. They then didn't do it, and the Court of Appeal has told them yet again that they have to do it.
If I may follow up. So if the civil courts give these appeals, it seems to me that there must be enormous deference to the Maori courts, especially when we're talking about matters that are within their expertise. So what standard are we going to apply?
Normal judicial review standard I'm just trying to think of some example. Normally, they haven't arisen where there is a cultural or tikanga dimension that's the problem. So the review is more about natural justice or something like that. I think the courts would be quite deferential to assessments of tikanga, although having said that, there's some pretty awful decisions back in our history made by the Maori Appellate Court, which of course was not a Maori institution. In fact, the Supreme Court has recently reversed, has reversed both in Ngāti Apa and in Paki, has reversed old decisions taken or based on findings of the Maori Appellate Court, which when you really analyse them just didn't stack up. But those were on matters of custom.
Good. Well, I think that's been a really very interesting conversation. Thank you very much indeed, Sian, and thank you to everybody who's been here. There's some snacks and some drinks outside, so please do join us for a glass of wine, and please join me in thanking both Sian, Elias and the two discussants who've given us such an interesting conversation.